Good afternoon. This is attorney Elise Gross with the Presser Law Firm, speaking about asset protection, myths, and fallacies. A little about myself. I've been an attorney in South Florida for over 25 years, and our firm practices in asset protection and estate planning. Every month we have a webinar. We alternate between asset protection and estate planning topics. If you have any topics that you'd like to hear about, please feel free to write in to info@assetprotectionattorneys.com and be happy to potentially entertain that topic. In addition, we have a newsletter that we send out via email every week. If you're not already receiving it, we'd love to have you receive it, so please let us know. And we also offer preliminary complimentary consultations for anyone that's interested. So please feel free, email in at any point. In addition, if you have any questions during the course of today's webinar, please email in, because if we have time, we'll do some Q&A at the end. If your question doesn't get answered, then we'll email back a response. We're basically going to be speaking today a little bit about what asset protection is, who actually needs asset protection. We're going to focus on the ethics of asset protection and the most common asset protection myths and fallacies. So what is asset protection? Our firm's definition is asset protection is a legal and ethical way of protecting your personal and business assets from future threats and creditors. So we'll talk a little bit about this today, but it's about future planning, if at all possible. It doesn't mean you can't asset protect if you've already got some issues, but you are somewhat limited. But the ideal asset protection is when you do it legally, ethically, and your goal is to protect from future potential creditors, not somebody who exists today. So let's start with who is actually needing asset protection. Well, everyone really can use asset protection, because it doesn't matter how much you have in assets. It can be a little, it can be a lot. In fact, those who have the most need asset protection the least still need it, but they need it the least because if they get in a lawsuit and they get sued and they get a judgment against them, well, if the judgment is collected upon, then they're going to suffer a loss. It's going to be painful, but it's not necessarily going to be catastrophic. It's not going to wipe them out completely. So if I have $50 million and somebody gets a judgment for $5 million and I actually have to pay that amount, yes, it's going to be unpleasant and it's going to hurt, but I'm still going to have $45 million left over. Whereas somebody who has, let's say, $1 million and they get sued for $1 million more or even a little bit less, that could wipe them out in total, and then what are they going to do? They won't have anything left. So it would be totally catastrophic. So really there's no threshold from a monetary standpoint as to who needs asset protection. You should look, whenever evaluating, at what the person's life is like. Are they in business? Are they driving a car? Are they in a specific litigious type of business, high liability? That's all looked at in addition to what are my assets? Where do I live? What are my exemptions in my state? We have to look at that entire picture to figure out what a person needs in terms of asset protection. They all already may be protected if they have all their assets in an exempt asset. But without further evaluating, it's really hard to tell whether that person needs further protection or not. In fact, if you already have some sort of asset protection plan, whether it's just that you have things as exempt assets or that you've already moved forward and done some proactive planning, it doesn't mean that that plan is going to be good forever. It's very important to keep up on it, have it relooked at every few years just to make sure that it's the right current plan for you. What worked 5 years ago may not work now. Your assets could be completely different. Your financial position could be different. Your business might be different. Your family situation might be different. You just may have other things that are involved that may change the way your plan is playing out, and it may not be the right plan for you. And if it is, great, nothing further to do. But you should, just like you have a checkup every year for health purposes, you should have a financial checkup so that you can see if your asset protection and your estate planning are up to date. When we look at a person to evaluate whether or not they need asset protection, we do look at two big factors. One is, what do they do for a living? What's their business? Are they in a field where it is so common that they're going to be sued that, that they need more asset protection than somebody else? And also, where do you live? The reason where you live is so important is because there are financial exemptions, creditor exemptions that are available. Every state is different, and where you live can be critical. For instance, I live in Florida, one of the best creditor protection states. We have things like homestead, and retirement accounts are protected, and life insurance is protected, and the homestead is the biggest thing we have here. Wages, to an extent, are protected. So if you're living in a state like Florida, your asset protection plan will probably involve using some of the exemptions. So that's a very big factor we always look at in terms of who's domiciled where. So now let's get to the crux of it, the ethics of asset protection. I hear it all the time when people say to me, asset protection, is it legal? Aren't you just hiding your assets? Aren't you defrauding your creditors, et cetera, et cetera? The answer is no, not if you've done it properly. If you've done it legally and ethically, then absolutely not. There's nothing wrong with trying to protect yourself from future potential creditors. As I said earlier, if you already have a creditor, then it might be a little bit different. But if we're talking about future potential creditors, you have every right to protect what you own. Why would anybody have a right to your assets if they don't have a judgment against you? And why should you, as an American citizen or wherever you are, not have a right to protect yourself from somebody suing you? Now, that doesn't mean that if somebody sues you for some actually valid reason and there's a judgment against you, that you're not going to pay anything. That's a big myth, and I can't remember if that's further down in the slides, but that's a big myth, because if somebody gets a judgment against you and you have an asset protection plan, it doesn't mean you'll never pay a dime. It just means that you're going to be in a much better negotiating position and you'll pay a lot less. So this is a very important point to remember. Asset protection is not about paying nothing. If it's a true, valid claim, then you'll probably end up paying something. It's just how much are you going to pay, and that's where the asset protection plan comes in. You must use qualified people. If somebody tells you they do asset protection, that doesn't mean they do asset protection. They may just do estate planning. Some estate planners are absolutely fantastic, but they don't look at anything from a titling perspective. They look at it from what's going to happen after you die, what's going to happen with your estate taxes. All very critical things to look at, but that's not the same thing as how do I own something so that a creditor can't get at it, so that I actually do have something to leave at my death. So when you evaluate who you should be using, make sure you're using a proper asset protection attorney. Make sure you have a good CPA, someone who is going to be completely knowledgeable about anything that you are setting up, whether it's in business or whether it's personal, that the CPA is totally on board and knows exactly what to do and what financial disclosures need to be filed, what tax returns need to be filed, because the people that get into trouble are usually the ones who don't file the returns, who don't disclose that they have, let's say they have a foreign account or a foreign company, foreign trust. If you don't disclose it, the penalties are huge. So you must use a qualified CPA. And of course, I'll repeat, you must file every tax return and disclosure that's required. So make sure that all of your professionals are talking to each other so everyone is on the same page, because if you file all your returns and you file your disclosures and you use competent people, then there's absolutely no problem with creating an asset protection plan to void off future potential creditors. Is it legal? Well, it's legal as long as you do it legally. As long as you're not trying to bury fraudulent assets and committing any crimes, money laundering, or anything like that. You can legally shelter your assets. You can legally set your assets up both inside the United States or outside of the United States, as long as you're compliant with all laws in both jurisdictions, as long as you're compliant with all tax filings. If there's a gray area, if you have to think about it, don't do it. It's probably not legal, and if it is legal, it may not be ethical. So avoid all the gray areas. Know what your options are, and only do those that are legal and ethical. And then asset protection is absolutely not a problem. The law does allow you to legally shelter your assets. So can I afford it? Well, can you afford not to do it? If you've got assets and if somebody sued you, it's going to wipe you out, or it's going to significantly impact your lifestyle, then how can you not afford to follow through on an asset protection plan? Why should your creditor reap the benefit of everything that you've worked for? You've spent all that time and energy and money investing in your own future and in your own business and in your own wealth. You have a right to protect it. So asset protection, doing a plan, is an investment in that wealth. It's same as any other investment. If you're going to put money in the stock market, well, that's an investment. You're hoping for growth. If you put money into an asset protection plan, then you're going to be protecting all the money that you've earned, and hopefully the future earnings as well. It's a lot less expensive to plan ahead than it is to defend a lawsuit. What a lot of people don't realize is even if you get sued and lose, and win, there's still a high cost to that litigation. Very few things are actually taken on a contingent fee from an attorney, which means you're paying by the hour. And if you've ever had the opportunity, not the good opportunity, but the opportunity to be involved in a litigation, you'll notice that before you even blink, the dollar signs are huge. I know I had an issue years ago where it was a frivolous lawsuit, and it didn't even matter before I closed my eyes. It was $20,000. I don't even know what they did for $20,000, but it was gone in a month, and there wasn't even any validity to the lawsuit. So you have to make sure that you're looking at things from all angles. So it's much less expensive to plan ahead than it is to defend that lawsuit. And not every plan is going to cost you a tremendous amount of money. There's low-cost alternatives. You have to evaluate each asset and how it's owned and what you can do to protect it, and then decide, do a cost-benefit analysis. Is it worth it? And you want to just, check out all your possibilities before you make a firm decision. Don't spend any more than necessary, but know what your priorities are. What do you need to protect? And don't be cheap about it, because if you are, then that's penny wise and pound foolish later on when somebody decides to sue you. The word hiding. Every time somebody says to me, I want to hide, I say, stop right there. I don't want to hear that. That's not what we do. Asset protection is absolutely not about hiding. You can keep things private to an extent, other than keeping it from the IRS or your CPA, but that's not hiding. Hiding is where you jump into the realm of the illegal and unethical. I have no problem with privacy or even secrecy to the extent that it's permissible under the law, but you never want to hide your assets. In fact, what you should always do is take a position that if you ever do get sued, that you would be prepared to actually present your plan to the creditor's attorney and just say, here's what I've got, now try to collect. So yes, it's nice to keep it as secret as possible, but you want to have your plan so solid that you're able to present that and show that as your defense from a judgment. Not from the liability perspective, but to present it to the other side and say, hey, if you want to sue me, you can go ahead and sue me, but I'm not going to be collectible. Now, that doesn't work for everyone, but that is a position that some people will take. The key is have that option. If you've got your plan positioned in such a way that you can use it as a defense, then great. You don't want to volunteer what you have until after the judgment, and when they start trying to collect, that's fine too. But understand that it's never going to be hidden. At some point, whether it's before or after that judgment, you're going to get subpoenaed. You're going to have to produce all the records, so it's going to come out. So never think of it as hiding. One of the things that I see, or used to see a lot more, but thank goodness we're not seeing it as much, is titling assets to other people. People come in here and they say, oh, no, I'm okay. I've done my asset protection. I put everything in the wife's name, or I put it all in the children's names, or yeah, I don't really own that. My friend owns it, wink, wink. That doesn't work. That's called titling something to a straw person. Think of it this way. If I title my house to my friend and I get sued, sure, I wouldn't own the house. You're right. That works. Well, what if my friend gets sued? Well, my friend gets sued and they take my house. And what if my friend and I have a fight? Well, I don't own that house. And I could say it's mine, but my friend's going to be, well, what do you mean? It's not your house, it's my house. You're never going to see that again. So titling it to straw people does not work. Titling it to a spouse or your children doesn't work. Again, because maybe they get sued and then your assets are taken. With a spouse, it's even better. What if you get divorced? Well, the spouse is in a great position because they already own all the assets. And they're going to say, oh, it's not even marital asset, it's a separate asset. So that's not going to work. A lot of our physician clients were doing that for decades. They're starting to come around to realize it's not the greatest idea to do that, and doing proper plans, not involving sticking everything in the spouse's name. And lastly, one of the most important things to know about asset protection is about fraudulent transfers. A fraudulent transfer is when you have a creditor and you transfer assets out of your name so that they're out of the reach of the creditor, which means that you're making yourself in a position where you're unable to pay the creditor based on the transfer that you've done. So you always want to avoid fraudulent transfers. What you need to be aware of is a fraudulent transfer is not a criminal act. It is a civil remedy that a creditor has. So what does that mean? If somebody sues you and they get a judgment against you, and they now have the opportunity to go through all of your finances and all of your papers, at that point, they may say, wait a minute, you are already being sued and you transferred these assets to a friend or to a relative. Well, what they can do, depending on what state they live in and what the laws are, and depending on how much time has passed, they can say to the judge, we want to claw that transfer back as a fraudulent transfer, that it was done to hinder and delay the creditor receiving their money. So that's what a fraudulent transfer is, and it's not a criminal act unless there was actual fraud there. But generally, the word fraud in this sense is not meant to be a criminal act. You always want to be wary of fraudulent transfers because that is always a risk. So you want to, that's why we always say, plan ahead, be proactive. This is my favorite one because I'm an estate planning attorney. We have clients come in I would say 50% of the clients who come through the door who have a revocable trust think that they have asset protection. They have no asset protection if they're relying upon the revocable trust. Revocable trusts are great for estate planning. They help direct where the assets are going to go when you die. They help if you become incapacitated. They can even be used, if properly done, for asset protection for future generations. They do not work for the person who has created them. It is a strictly estate planning tool. If I have a revocable trust, I am able to change it, and therefore, and to take all the money, therefore, it is not asset protected. So that is one of the most common fallacies that we see all the time. So if you've done your estate planning, I applaud you. That's wonderful. But you need to understand the difference between the revocable that you can change and take back and the irrevocable trust, which you're giving away assets and can't take it back. Asset protection fits kind of in between. You want to be able to control something without a creditor being able to get at it. Revocable trust doesn't do it for you. The irrevocable trust can be used with asset protection. It is a tool, but it's not the be-all, end-all because you'd be giving up your control over that and the benefit of the asset. So where you need to be is somewhere in between. So I spoke about this a little earlier when I talked about proactive planning. Can something be done after you've already been sued, after you've already got a potential creditor? And the answer is yes, with qualification. Your options are going to be limited. There are certain things that are going to be allowed. For instance, in Florida, you might be able to put more money into your homestead. You may be able to protect other assets and leave out enough to be able to pay that claim. It doesn't mean you have no options. It just means your options are definitely much more limited than if you had been proactive. We have to evaluate each and every situation on a case-by-case basis in order to determine what options you have available. Sometimes there may not be any options, and that's going to be because it depends on what your assets are. If you only have a little bit of money and that's what you need to live on, then there may not be anything to really put away. But if you can make use of any of your state exemptions, if you can look at what you're going to be doing in the future and maybe plan proactively for any future endeavors, there are some options. But I'm not going to lie to you, it will be limited. That's why it's imperative that you plan ahead. Be proactive. Not every asset protection plan is the same. It can't possibly all be the same because not everybody has the same assets, the same threats, the same family situation. Every person has to be looked at individually. And when you look at somebody from an asset protection standpoint, we have to look at every asset they own, how each asset is titled, how each asset is taxed, because that definitely guides us into how we can protect them. What are their future plans? What is their future possibility in terms of income? Because you have to plan out, depending on what you set up for somebody, what's going to be their income stream. Do they have partners involved? What states do they operate in terms of their businesses? What state do they live in? You're not going to find one plan that does it all. There might be components of plans that are similar, but every person needs to just be individualized and customized in order to make sure that you asset protect everything. And again, asset protection could also mean looking at whatever the state exemptions are to incorporate those into your asset protection plan. A really good asset protection plan can really be called an integrated estate plan. It will intertwine with your estate plan so that you're protecting what you have today so that there's actually something to leave in the future to your heirs. So that's why I like to call it an integrated estate plan because they're not isolated. You can't really do one without the other. So you want to just make sure that if you're in a state where your asset protection attorney doesn't do the estate planning, you want to make sure that those two attorneys are speaking, because they can coordinate and make sure that everything works together. Okay, I know today was short. We just wanted to give you a quick overview. Again, we do our webinars every month. Next month, we're speaking about the revocable trust, which I mentioned earlier today. If you give me a moment, there's a couple of questions, so just hold for a moment and I'm going to grab those questions. Okay, I'm going to start with, we'll have time for 2 questions. So the first one was, if I'm doing an asset protection plan, should my spouse be involved in the plan? And the answer is, that really is going to depend upon you and what your family situation is. And do you have a prenuptial agreement? So if you have a prenuptial agreement, then depending on what that says, your spouse may not be a part of your plan unless you do still keep some assets jointly. Every prenuptial agreement is different, so we would have to look at that in your particular case. But if your family situation is solid, you've been married for a long time, all of your assets are joint, then it makes sense for both of you to participate in the plan, and that helps with some estate planning as well. The other question I got was, well, why can't I just wait until I see a problem? Why bother with an asset protection plan now? Why spend the money? Well, the answer is that if you wait, then your options are going to be limited. It is better if you do your protection proactively and then kind of tweak it as you go along. If something hits and you have to evaluate your asset protection plan with your attorney, that's fair, but it's better to just be protected in advance. Okay, and I'm getting another question on the chat. I have Forex trading accounts overseas. I report a profit and loss to the IRS for the last 3 or 4 years. Is there anything I might need to know related to asset protection? So the answer is you must report because you're a U.S. citizen. You just always report, file all disclosures, and make sure that you're filing whatever your CPA tells you to file. And it doesn't hurt to do some research on your own in terms of what forms need to be filed, because not every CPA knows. That is one of the biggest pitfalls that people come into. If you do have any foreign accounts or foreign companies, that reporting requirement, the fines can be up to $10,000 per occurrence. I think that's what that Manford case is about. Some of that is about not reporting foreign stuff. So it is critical. You want to report. Yes, you know, it's painful to have to report that stuff. Does it open you up to future audits? I've never really seen any sort of statistics on this, so I don't know if it does or it doesn't. But you want to make sure to be the one that's reporting. Don't be the one that's not reporting. I want to thank everybody for participating today, and I hope we'll have you again September 20th for our webinar on revocable trusts. If you're not already receiving the newsletter, please make sure to email us at info@assetprotectionattorneys.com or call us, and we'd be happy to get you on the newsletter or set up a preliminary complimentary consultation to discuss any of these topics relating to asset protection or estate planning. Thank you so much and have a great day.